Morning, Your Honors.
Morning. Mr. Morris. Okay, we've got you both now. Mr. Shapino, whenever you're ready.
Thank you, Your Honor. May it please the court. And if I may, I'd like to reserve 5 minutes for a rebuttal.
All right.
I know this is something that the court hears on occasion, but we believe this is actually a relatively simple appeal involving an interpretation of a relatively simple 2-page contract. I think this is one of the few issues we probably agree with the parties agree on. But to frame the issue on appeal, pursuant to this short agreement, on March 29, 2021, either my client, Arabus, was entitled to almost $500,000 in escrowed funds, or the appellee union was entitled to the escrow funds. And union's position here, in this case, the appellee is, no, we satisfied the conditions within the 90 days specified in that amendment to this aircraft purchase agreement, which I'll get to in a minute. And our position in the appeal is no, indeed, you did not. So at that moment, when the clock ticks over from the 28th to the 29th, a legally significant thing happened and somebody was entitled to the funds. In my reply brief, Your Honors, I put the date as April 1st because I'm incapable of counting 90 days from the date of closing, and I apologize. But the parties were smarter than I was, which is a low bar, but they actually put the date in. They put March 29, so we know the exact date. And just to cut to the chase, this aircraft purchase agreement was the initial document that drove everything. Lots of reps and warranties in there about the title to the document. We have the seller. There's no cloud on the title. There's no restrictions, no claims, no overhaul or repair arrangements, nothing. And so before closing, we learned that's not necessarily true. There's a bit of an issue. And you'll hear both sides talk about JSSI, Jet Support Services. And they had filed this letter and an affidavit with the FAA, the Federal Aviation Administration, saying, hey, we're owed $500,000. And we didn't know about this, we Arabus, until right before closing. So we say, hey, time out, let's slow the roll. We're not going to close unless there's an accommodation here. And fortunately, the parties agree. Yes, let's accommodate. Let's do this thing. We'll create this amendment, and we'll agree on the conditions on how and when the escrowed monies are going to be dispersed. And so here we go. Now let's get to it. The 2-page document at the heart of this case. It is very short. And page 1, paragraph 1, it's simple. First, the timing. 90. This is something we'd like to see Arabus and the seller union. We want resolved. So let's do it in 90 days on March 29. This money's going to somebody. And these are the two things that you, the seller, you need to do. And the first is obtain a withdrawal, written confirmation from the buyer along with it, but obtain a withdrawal of this JSSI claim from the FAA. And we have examples. They agree, and it's helpful. Here are the 2 examples of things that could accomplish this withdrawal within the 90 days, which would lead to Arabus's written provision. And one was transfer the claim to a cash or surety bond. Okay, that's a good one. Seller could resolve the claim by a final court order, and I'll come back to that one in a minute. And the second way, the second path was within the 90 days, again, FAA and JSSI needed to confirm in writing that there's no encumbrance on the aircraft. So those are the 2 things. If those don't happen within the 90 days, the money goes to my client, Arabus. And so the parties close.
Well, can I pause you there, Mr. Shapino, because
Of course.
the First Amendment has a little bit, it doesn't end with just the money getting dispersed. It has expressed language about how the money gets used, including a provision that states the buyer, quote, shall, uses the mandatory shall, apply the escrow holdback to obtain withdrawal of the JSSI claim of lien. That's all that you can do with that holdback money. It seems like, though, the way you all are reading it, you're reading it more like that holdback money or that provision almost acted like a liquidated delay damages clause. Like, if you don't get this done within 90 days, we're out 500. We're going to agree that we're going to knock off 500K from the purchase price. Given that the contract's provision tied you all's hands, so to speak, with what you could do with that money if it got sent over to you, combined with the record evidence that JSSI, I guess they submit an affidavit saying, yeah, no, we're out. How do you reconcile all that? How does all that become consonant with each other?
So if we're having a discussion about what we did with the money after we received it, That's a good discussion because at least we should agree that we were entitled to the money on March 29. Because you can't argue about what we did or didn't do with the money until we were entitled to the money. That's not Union's position here, right? Just so Your Honor understands. Union's position here is we satisfied these conditions within the 90 days. And we were entitled to the funds
Well,
on
for my
that 90
edification,
day.
Mr. Schifino,
Of course, Your Honor.
how did you satisfy that? What did you do to
Oh,
satisfy the condition?
A great question that I hope the court asks my colleague, Mr. Morris, because it was their burden as the seller to satisfy those conditions, not ours. If that didn't happen within the 90 days, then the money comes to us. And that's a good discussion. I'd love to talk about what we did or didn't do with the
Well,
money.
but it comes to you for a specific purpose, and that is to take care of the lien.
It
But
does,
since it's
Your Honor.
already taken care of, it can't fulfill that purpose.
Well, let's talk about
I think the trial court called it a windfall.
The trial court did, but let's talk about what the question, if I may, Your Honor, taking care of the lien, right? This doesn't have anything to do with a lien. It has everything to do with a claim that there's a lien, a claim. And if it was all about a recorded lien, Your Honor, isn't that what the parties would have put in the amendment?
Well, is there any dispute at this point that JSSI has withdrawn their claim of lien?
Well, yes, there is, because yes, absolutely. And you have and to get to Judge Morris's question, what happened within those 90 days? What did Union, the seller, do to try to obtain a withdrawal of the lien? Because that's what they had to do. The seller had to obtain withdrawal of the lien. And the seller, on the 14th, 2 weeks after closing, January 14, remember I talked about one of the examples was get a final order, court order, establishing this withdrawal from the FAA records. That's what you had to do with this claim. And so they file a lawsuit up in Cook County, Illinois, to try to get withdrawal of this claim. But that doesn't happen. It doesn't happen within the 90 days. In fact, there's a counterclaim by JSSI, and they litigate into July of 2022. And remember, there was a question about an affidavit from JSSI saying, hey, we're out. That affidavit didn't come until July of 2022. Remember, the only affidavit that existed was the one filed with the FAA. And that's been in place all the way through until July of 2022.
So at the time of the summary judgment, then, JSSI had indeed said, practically speaking, we're out. We are no longer asserting a claim of lien. That being the case, you couldn't use that money in any other way except as, I mean, presumably your client's not going to provide a windfall to JSSI and double pay them if they say we're no longer asserting a claim of lien. It can only function as liquidated delay damages, which you all didn't negotiate.
A couple of points here. After the July settlement and after this affidavit that JSSI signed to resolve this claim that was still there for the 500 days after the closing and not the 90,
right,
we filed, and it's been unrebutted, we filed an affidavit of our client with title reports through 2022, including after the settlement. And that claim of lien in that affidavit is still on the FAA title report. And Your Honor, I could direct the court's attention to it. It's in October of 2022. This settlement and this affidavit didn't magically create a withdrawal of this claim of lien from the FAA records. It didn't happen. And through the judgment entered in this case, that claim was there. And so the question I would pose to, not to the court, but of course the other side is, what did you do, if anything, within the 90 days to resolve this issue with the claim of lien? Nothing. Even though that's their, again, I understand where the court's going, and that's, I'm ready to discuss that because that's the conversation I wanted to have with the court. Their position here is we did resolve it in the 90 days. We have this arrow title document. Yeah, we both talk about it in our briefs. March 17, I think, 2021 document. That shows the claim of lien.
Shows an unrecorded claim of lien, is that right?
Yes, exactly, which is exactly the words we used in the amendment that needed to be withdrawn. The exact words, that this is an unrecorded claim of lien that the seller needs to resolve.
So here's my question, I guess. Under the First Amendment, the contract, which I think you very candidly say it was looks like it was kind of quickly put together, a couple pages.
Mhm.
Hey, fair enough. They've got a closing date coming. They're trying to keep the deal. They're trying to keep the deal going while they work through this problem. That kind of thing happens. Other than the provision that says you can have the clawback money dispersed to you, but you shall use it to clear this claim of lien. Other than that, is there anything else in the First Amendment or the original contract that says what you get if they fail to clear up this problem in 90 days? Or is that the extent of your remedy? You get this clawback money and you shall use it to clear the claim of lien, or to get the withdrawal of the claim of lien.
Understood. So there's nothing else, there's nothing in the original contract, the aircraft purchase agreement, and nothing else in here. But what we're forgetting, Your Honor, is we received the escrow funds at the end of June, right? So we got them beginning of July, we have the escrow funds. And the plaintiff files suit in September. I'll be like the 13th, right? And you look at what do the pleadings say? What is the remedy that plaintiff is seeking here? Wouldn't one think you, Arabus, you have the funds. We are compelling you now as the party with the funds you need to go resolve this claim of lien. Ball's in your court. But that's not what they do. In the complaint, the plaintiff alleged, the operative pleading here, and the pleading upon which this order is entered, doesn't do that at all. What it says is that this amendment was prepared between the parties to protect us, Arabus, in case there was an actual lien. Those aren't the words in the amendment. They're wrong. This case started off on the wrong track. And they followed, and again, the pleading, the operative pleading is no lien, no recorded lien. JSSI failed to properly record the lien. And going back to Judge Morris's point, that's not what the amendment says. Unrecorded claim of lien is what the amendment says. That's what needed to be resolved. That's not it. That's not all, Judge Lucas. Not only does that's the complaint, that's the dispositive motion, the affidavit, always 24 times, I think it's 24 times. In this answer brief, they're telling the court, no recorded lien, no recorded lien. We resolve this in the 90 days. So this complaint, again, the operative pleading, what's the relief, right? I said, wouldn't it make sense for them to say almost like a specific performance, go deal with the claim, you've got the money. But that's not what they did. They did the opposite. They asked the court, the trial court, which the trial court did, declare that the claimant does not have a recorded lien on the FAA registry. We agree. That has nothing to do with the case. But the trial judge got confused, spent almost a paragraph of his order talking about whether or not there's a recorded lien. It makes no difference because we weren't talking about a recorded lien. What's the second declaration that they seek? Declaring that the seller is entitled to release of the funds. All right, I get it. You allege that you, within the 90 days, satisfied the condition. You want the money. But here's the kicker, Judge. Instead of compelling us to do what we were contractually obligated to do, they sue us for the opposite and join the release of the funds to anyone other than the seller. And that's a quote. That's the relief they sought. And so we're getting sued. And the declaration is not only that, and we still don't quite understand the route they went, because it's the same route that they took with the escrow agent and the trial court is, here's the arrow title document, there's no lien. And that's the end of the inquiry. And they take that position with the court in their answer brief, but they're wrong. They're wrong. And so in a vacuum, Your Honor, to Judge Lucas's question, in a vacuum, that's the right conversation to have, and the exact same conversation I would have. Logic would have suggested they would have come to us and made a demand for indemnification, something to say that you've got the money, we're doing this, this is what the contract says. They did the opposite. They sued us and said, you're not entitled to it. On day 90, you were not entitled to this document. To the funds, forgive me. And in fact, we were. And because we were, Union, Arabus, you can't do anything with these funds until we get a declaration from the court.
And forgive my ignorance about aviation law. If this is just a patently obvious question, I apologize.
No such
Is
thing.
it such that only, because it sounds like the computer database of the FAA is still reflecting JSSI has a claim of lien, not a recorded lien?
Exactly right. You're right.
If that is so, and if this is outside the record, tell me, or if it's just a matter of a federal aviation law, please enlighten me. Is it set up such that only JSSI can withdraw that entry, the claim of lien, or can anyone provide information to the FAA, say, hey, look, they are no longer asserting a claim of lien.
It's outside the record what happened, but yeah, but that's the mechanism that was contemplated in the amendment addresses how that would have happened. That the FAA, we addressed that. The FAA and JSSI provide written confirmation that there's no encumbrance. That's one of the ways. That doesn't apply here. The union's not arguing that even applies here. Another way was that we, the buyer, we could provide written confirmation of a withdrawal, and this is all information that union could have taken to the FAA. And what
Mr.
happened? What happened
Shapina,
for me?
I'm
Your
sorry
Honor.
to interrupt, but I just want to let you know your 5 minutes.
Your Honor, I just get talking, and I could go for the next 2 hours. So
It's your time, and you can use it however you want, up to 20 minutes.
I get the hook at 20. But I don't mind cutting down to about 3 minutes if I could get just a couple more minutes.
Sure.
I want to explain, I want to make sure that the court understands our position. This isn't just a simple case of us keeping the money and finding a windfall again. You have a plaintiff, a seller union, who filed this lawsuit and specifically challenged us from doing anything with the money other than holding it until the trial court rules who's entitled to it. So they can't complain into this court and come here palms up and say, well, they didn't do what they were contractually obligated to do when you sued us and you told us not to. And you demanded that we not to. And so we did litigate this with the trial court until it was resolved. That's what we did. And one of the things the trial judge did here, which I didn't quite understand, is we asserted a counterclaim and we asserted a damage claim because this is a claim of lien that went on a lot longer than it should have. Even the settlement didn't resolve the claim on the title. So we had an affected title up through 2022 and up through the entry of this judgment. There's a problem here, and there's nothing in this contract that limits a damage claim. It doesn't say your sole remedy for damages for anything that's excessive is going to be limited to this $500,000. We don't even think that that's the right direction. There is an entirely independent damage claim, independent of this $500,000. And we asserted that, we alleged that, and we filed affidavits in support of that. Those are all in the record. Now, the union had an opportunity to say, no, fact issue on damages. No, we need to develop discovery here. But they didn't. And I get it. They have excellent counsel. And their approach was, we're going to win on the 90 days. We were entitled to the funds on day 90, and they never should have had them. So why would we challenge or rebut with evidence their damage claim? So they made a choice, and that choice was at their own peril. That is unrebutted at record evidence in the case. And their response to our dispositive motion was a paragraph, and it was, look at our motion for summary judgment. Look why we were entitled to that money on day 90. So again, that's their argument. They repeat it again and again. There was no lien. We proved it with the Arrow title document. It's all about a lien according to union. We were entitled to the monies on day 90. And they're just mistaken. That's not what happened. And that's, unless you have any more questions, I think I'm probably down to 2 minutes, Judge Kelly. I'm sorry.
You are.
Thank you so much.
Sure. Mr. Morris?
Good morning. May it please the court and counsel. I'm Hal Morris, and I represent the Appley Union Leasing here.
So,
I
Mr.
think this
Morris,
case-
if you don't mind, I'd like to just launch into the question of the day.
Sure.
And of course, make it clear that you and I are not related, so Mr. Shafino doesn't think you're going to get the family deference from me. Is that right?
I was hoping for that, but no, we won't.
Okay. Well, I asked him the question I really should have asked you.
Right.
What exactly did you do in the 90 days after closing that entitled you to this money?
There are two things. The first thing is the amendment to the contract contemplated the use of the holdback for purposes of addressing a claim for lien. What we did with regard to that is, number one, we determined and provided a title report, number two, to the escrow agent that there was no claim for lien filed against the aircraft.
But the title report said there was an unrecorded claim.
There was an unrecorded claim for lien, but that is not an enforceable lien. Later,
I understand that, but we're talking about $500,000 here. If
Right.
you were the buyer, would you have been comfortable with that?
if I was the buyer,
Well, that's good for me.
if I was the buyer, Would I have been comfortable with that? The answer is yes. And the reason being is the party's intention in the contract was to utilize those $500,000 for a particular purpose only. And if there is no claim for lien that is filed, you cannot get it. In other words, you can't undo something that doesn't exist. Secondly, in terms of the use of the funds, when the escrow agent turned it over ultimately to the buyer, it was turned over, I think, as either yourself or Judge Lucas said, for the sole purpose of addressing the possible claim. And there is no claim to address because, as we now know, JSSI has withdrawn as of December 1st of the contract year 2020 any claim that it has of a lien. And I think what this really goes to is the starting point that the trial court began with. And it really is the last time. Yeah.
But just to interject here, that happened in December, and your magic date was March the 29th. You had to do something by. So why do we care what happened in December?
We care because the contractual intention of the parties is to use that money for a particular purpose, and it can no longer, and actually at the time could not have been used for that purpose because there was no claim for lien, and it then was acknowledged later there was no claim for lien. So to allow the buyer here, Arabus, to retain the money essentially does, as the trial judge suggested, it gives them a credit of approximately $500,000 and reduces their purchase price to $7.1 million from $7.6. What I would suggest is that this court, and actually the last time I stood before this court and Judge Kelly, we argued about what is a contract interpretation. And there, it's clear that under Florida law, and probably the law of all states, it's the intention of the parties. And that's gleaned from the language of the contract. And here the intention of the parties is very clear that the escrow holdback is for the sole purpose of addressing the possible claim of an encumbrance. And there is no encumbrance on this aircraft, and there was no encumbrance on this aircraft. The amendment itself did not say, as Judge Lucas suggested and what the Arabus is suggesting, that it can be used for some other purpose, for a damage claim, for a delay claim. If they wanted to say that, the parties could have written that, and we don't rewrite contracts. To permit this to go forward the way it is and allow the money when there is no claim, there was evidence that there was no recorded encumbrance, and therefore you could not have removed a unrecorded encumbrance, would be essentially contrary to the use that the amendment said the monies had to be used for. What's important when we look at this case, I think, is we go back to the fundamentals, and lawyers always like to say that, and that's what we argue to courts, but the fundamentals are, what did the parties intend and what did their writing say they intended, because that's the best evidence of their intention. And here the intention has to be read so we don't render provisions of the contract meaningless, and we don't construe a contract in a way that does not give reasonable meaning to all of its provisions. And the only way to give reasonable meaning to all the provisions, including the March date, including who gets the money, be it seller or buyer, is to look first at that sentence, what is the purpose? And the amendment had one purpose and one purpose only, which was to permit the sale to go forward and to address a claim for lien by JSSI.
Well, can I pause you there real quick just to dovetail into something Mr. Schifino argued towards the end of his argument. The deck action that you all file seems pretty clear. I mean, it's about who's entitled to the clawback provision.
Mm-hmm.
You could read their counterclaim as seeking, they don't seek a counter declaration, they seek a breach of contract. And in that counterclaim, they allege at paragraph 18, Union Credit's breaches in the plural of the agreement and the amendment, and Union Credit's wrongful assertion that Arabus is not entitled to utilize the escrow funds, blah, 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 have caused Arabus damage due to Arabus being unable to sell or obtain financing for the aircraft, while JSSI's claim of lien is unresolved. what if his argument that, hey, okay, maybe there's a argument to be made that there's summary judgment appropriate for your deck action, but the trial judge may have gotten a little out over his skis, winding up the entirety of their counterclaim when their counterclaim seeks relief that goes beyond just who gets entitled to this clawback provision, but hey, we were damaged by the fact that this didn't get done in 90 days, like the claim of lien didn't get withdrawn within 90 days like it should have, and we want to assert that claim for damages. And the First Amendment doesn't really address who's going to liquidates damages for either side. So can you help me out through that?
I believe you are absolutely correct. There is no liquidated damage claim in the way you describe it. I don't believe the trial judge, as you say, got over his skis for this reason. The gravamen of the defendant's counterclaim really comes down to they should have had the money, and the seller, Union Leasing, should have taken some other action. But there was no other action that could have been taken other than the providing of the title report, which was done, which demonstrated there was no lien claim or an encumbrance against this aircraft. If they had other damages, that cannot be addressed through the $499,000. And I think what the trial judge was—
Well, and listen, I'm not going to disagree with you. I don't know about the gravamen, but certainly most of the counterclaim seems to be along the lines that you suggest, like, no, we're entitled to this clawback money, we're entitled to this clawback money. But I do see that, A, it's not a counterclaim for a counter declaration. It's a counterclaim for breach of contract claim,
Yes.
and they're not limiting themselves to seeking the clawback provision. They're saying they are breaches,
Yep.
plural, and that's caused them damage outside of the clawback because they can't sell and they can't obtain financing. And they do have a general, ad damnum wherefore clause that seeks damages, costs, attorney's fees, blah, blah, blah. So that's my concern is, and I don't know how well this was teed up below. I don't know, because the briefing was certainly very much focused on this declaration. I get that. I hadn't really thought about the scope of the counterclaim literally until Mr. Schifino just brought it up, and that's why I'm addressing it kind of in real time with you.
The focus certainly was with respect to the holdback amount, and as that holdback amount is addressed in the amendment to the purchase contract. I believe what the trial court did, and candidly, I believe our response to the counter motion for summary judgment by Arabus is indicative of the fact that, yes, they were treated as the same, because I think that's really what the counterclaim is. It's a counterclaim saying, because we should have gotten the money, not you, when you held it up, we were damaged. And that's not the purpose of the holdback. So I don't think the trial judge necessarily went too far. It wasn't really developed any further than that in the trial court. And as a consequence of that, I think the trial court looked very specifically at the intention of the parties with respect to the use of the holdback and did not countenance a counterclaim saying that because that use, which could not be achieved by the buyer, would give rise to damages. And therefore, the trial court rejected the counterclaim when granting summary judgment in favor of Union Leasing on the holdback, or the declaratory claim, as we say it. So I believe here what the trial court did and what we asked this court to do is that we have to look to the amendment, to the intention of the parties, and we respect that in what is written. Here the holdback was for, as both Judge Morris and Judge Lucas suggested, was for a very specific purpose, and that purpose only. It wasn't broader. Having determined that prior to the March 29th date, there was a title report saying there was no recorded lien, no lien could then be extinguished because you can't extinguish that which does not exist. And the seller should have received, upon its demand, the holdback. However, what occurred is the holdback was given to the buyer in June of that year. As the court points out, and Mr. Schifino points out, later in the Cook County, Illinois action, there was a specific statement by JSSI that as of December 1st, it also did not have a lien. And that, even though it happens after March, is indicative of what was the current state of events as of the March date in 2021. The examples that are in the amendment paragraph 1 are not examples that say you must do one of these things. It says such as. which is not a limiting type of language. It's a language just giving certain examples. And I would submit to the court that that's exactly what Union Leasing did. It received and it provided information to the escrow agent to demonstrate that the lien was not in place on the aircraft, and therefore there was no encumbrance, and therefore it should have been receiving the money, because to do anything else and provide it to Arabus would run afoul of the provision that says the sole purpose was to address that lien. Here, we do is we would respectfully request that the court basically respect the intention of the parties with regard to the use of the holdback monies, affirm the trial court's ruling on summary judgment and denial of defendant's summary judgment, and remand it for the very limited purpose of assessing prevailing party attorney's fees under the original contract section 8.14. So unless the court has any other questions, I appreciate the time.
Thank you. Mr. Shafino, you've got your 2 minutes.
Thank you, Your Honor, and I'll be brief. A couple of things that were said. Judge Morris, in response to your question, what did you do within those 90 days to resolve that claim? There wasn't an answer. The answer was we got the error title document that addresses the lien. What the error title document doesn't even say unrecorded, by the way, respectfully. It says stating that the claim of lien has been received, as well as the affidavit of breach. And the response from Union is, well, that shows that there was never a lien. So we were, just like I said, Your Honors, we were entitled to the money at the end of the 90 days because there was never a lien. There was never an encumbrance. That's the argument you just heard. There was never an encumbrance. My goodness, why did we have this amendment then if there was never an encumbrance? Of course there was an encumbrance. It was the unrecorded claim. And when it comes to damages, Judge Lucas, if you look at our affidavit, 321 to 326 in support of damages, it far exceeds the $500,000. Nowhere in my brief do I say we're looking for this 500 to apply to our, it exceeds $500,000. It's a bigger claim. I'm sorry, I'm rushing. The settlement document in July of 2022. Of course, imagine what Union's doing with JSSI. Of course, they want an affidavit that says there was no lien, but that doesn't rebut the affidavit where there says there was a claim. That is exactly what was filed by JSSI in September with the FAA. So that in September of 2020. So that affidavit was there until the middle of July. And you didn't hear any argument, because there is none, that the claim was still on the FAA records after this July settlement date. So we keep talking about this money being used exclusively for this claim of lien. We have been fighting and defending a deck action that says we can't do a darn thing with that money until a judge tells us otherwise. So the order here is a simple order. We urge the court to just consider it among yourselves, talk among yourselves. But we think what the order would look like is it clearly, you know, the trial judge and Union is wrong. At the end of the 90 days, the monies appropriately were dispersed to Arabus. It sounds like we agree on that now, because whether or not there was a lien is irrelevant. And then we have the damage claim. Certainly the judge, I appreciate the metaphor, way over the skis. That was not vetted, and it shouldn't have been dismissed on a summary judgment like that. But also use of the 500, just reminding the court of what was demanded in the operative pleading here. They didn't tell us to fix it. They told us to sit on the money until a judge tells us otherwise. Thank you, Your Honors.
Thank you both. That concludes this argument, and we'll call our next case, Ginsburg Clement versus Bennett Hunt Corporation.